Welcome to Cross-Examination with Jahan Kalantar, where perspectives collide and controversies arise. And today, I have a very special guest, a very dear friend of mine, and one of the few people that I would call if I was in legal trouble. My friend, my mentor, my buddy, Andrew Tiedt. How are you, buddy?
Man, I am excited to be here. What an amazing opportunity to chat to all your thousands of listeners.
Well, look, I think that we might have cracked the 3-figure number. Like, I think we've got 102, but that's okay because upon small things, big things are built.
102 very satisfied listeners.
Extremely satisfied. Now, I think we should probably start with a little bit of an introduction because I'd like to let the world know a little bit more about you. Tell us a little bit about yourself and, your subject matter expertise.
So I'm a criminal defense lawyer working in Sydney. I've worked in criminal law for the past 17 and a half years, and my practice is what I like to call crime and crime adjacent. So overwhelmingly, it's acting for people who've been charged with criminal offences, and then lots of sort of satellite litigation arising out of that. But my job is pretty much crime.
Yep. And the reason that Andrew and I know each other is that we became friends, I don't know, 5, 6, 7 years ago around the traps.
Something like that.
It's a very common phenomenon that you'll find that criminal lawyers tend to know each other. Some of us really like each other. Some of us dislike each other, but Andrew's been a dear friend. And it's not uncommon, actually, for there to be phone calls made from one to the other being like, hey, how would you interpret this particular legislation? Like, is this case really dumb or am I missing something?
I often call it doing a crazy test. So am I taking crazy pills or am I seeing this right? Because everyone else is seeing it differently. And I think they're just wrong. Aren't they wrong, Jahan?
Absolutely, they're wrong.
Absolutely.
They're absolutely wrong. And, it's really nice to have colleagues in the same sort of space.
100%.
And it's really, I think that one of the things I love about our job is the collegiality. Like,
For sure.
We really do have a community of people where, gosh, if you find yourself in a pickle, you can reach out and people
100%. I made a phone call just yesterday to a criminal law friend. So I had a particularly tricky issue that arose and I wanted to kind of run it past someone and get some ideas. That person works for a different firm. On one level, she's a competitor of mine. Picked up the phone, had a chat, talked it out. It's incredibly helppful.
Yeah. And I think that that's one of the things I've learned about practice as you move along. If you've got a question and you've done this for, I'm only, I think I'm 11 years out. If you've done it for about 11 years, you're dealing with pretty complicated things. And It's really important to be able to go to someone who understands it and just say, hey, have you done something like this before? Or, what do you think about this particular perspective?
Yeah, absolutely. There's no one who's been around so long or done so many things that there's no one who can offer a perspective or a different view on what's gone on. So I firmly take the view that there's always value in conclaving, as we often call it.
Hot tubbing. Hot tubbing, as the expert report says.
Absolutely. That's the only way to get better because there is no one who knows everything. And often I say to clients that I don't know everything, but if I don't know it, I'll know where to find it. And that might mean a book or a website or something, or often phone a friend.
Yeah, phone a friend. I think that the purpose of this podcast really, and I think that you nailed it, is let's talk about firsts. Because we're kind of at a stage in our career where I think we're doing pretty. I think on paper, if somebody saw us from the outside world, they would say, these guys.
What great beards is what they'd say.
Yeah, they would say, handsome, talented, intelligent. Wow.
Are they single?
Yeah. And I would say, get off me. How dare you? I'm happily married.
Never again. Never again.
But I think that people see kind of the outside and they forget that we're novices. And I always want to make it really clear. Every single time I go to court, I'll make some mistake.
Sure.
However, I think I'm smart enough to not make the same mistake repeatedly. And has that been your experience as well, as you kind of move and grow, that you still kind of make mistakes, but gosh, you make different mistakes and you learn from them?
I think you can't improve as a lawyer if you don't stop and think, that went well or didn't go so well, but what did I do that was good? What was bad? What could I have done better? As soon as you stop thinking about those things, you stop improving.
Yeah.
And again, a lawyer who's had 1 year experience or 60 years experience, every single one of them should be stopping and thinking about what they did and how it went and what they could have done better. And of course, I'm exactly the same. I look back on hearings or trials or sentences and think, gee, I wish I'd said that, or I wish I'd come at it that way. And it's only by that sort of self-reflection and that self-flagellation sometimes afterwards when you try to think, geez, what could I have done different? It's only by that process you improve. And no one is ever perfect. There is no perfect lawyer. There's no one who's learned every skill or mastered every task. You can just try to be better every single day.
You've nailed it. And I know that exact phenomenon. It's like, man, it's day 11 of the trial. I wish on day 4 I had zigged instead of zagged.
Yeah.
Why did I do that? And it's those kind of reflections that the next time you're on day 4, you go, okay, I'm going to zag this time. I'm going to make this choice. But let's go back to first. So you graduated. You've always been in crime?
Almost. So I finished uni in 2005 at Macquarie University. I did 2 years at the ATO. I'm doing tax litigation there, as I did College of Law and qualified as a lawyer. I was admitted in December 2007, so I became a member of the Law Society. And it's at that point you're able to call yourself a solicitor and go out and practice law. I had decided by that time that what I really wanted to do was advocacy. There's many, many different ways to practice law. Many of them don't involve courtrooms at all.
Yes.
Many involve courtrooms only occasionally. But I decided that the path I really wanted to follow was as much time in courtrooms and tribunals doing advocacy work, arguing for my clients, whether it was cross-examination or submissions or whatever it might be. That was where I wanted to be. And I spoke to some friends, and the advice was, well, either criminal or family. They're the 2 areas of law where you'll really get that hands-on advocacy experience. So I applied for some few jobs, got lucky. And in January 2008, I started at a criminal law firm and kind of haven't looked back since.
And I want you to kind of cast your mind back to, do you remember your first hearing?
So clearly.
So do I.
My first plea of guilty, my first hearing, my first trial, they are indelibly burned into the memory with a mix of nostalgia and regret as I think back to what I said and how it went, and I was such a baby, and
darling, we were all babies.
Absolutely.
Let's anonymize the cases are real, the rulings are final. Anonymize the information, but tell us about your first plea.
My first plea, I can still remember everything about it. It was at Waverley Local Court. It would have been in 2008. I'd acting for a young female client who had done a shoplifting. She was, as I recall, starting her, ironically, first day professional work at a company in the city doing some kind of work. And she had nothing to wear. And she was anxious and she was worried and she was stressed. She had some difficult mental health issues and was just in an absolute mess about her first day of work and what she was going to do. So in that really disturbed mental state and feeling as she was, she stole something. At a department store, she stole, it was either a jacket or a shirt or something like that. And got caught, of course, and was charged with shoplifting and came to court. And I went to Waverley, knees knocking together, really kind of terrified about what I was going to say and how it was going to go. And I had some psychological reports and references and handed this up to the magistrate. And I still remember it was Magistrate Lee Gilmore, who was a huge favourite of mine and a fantastic magistrate, now retired. And she read everything and she looked at me, and I don't know whether she could tell it was my first time or whether she could just kind of see the terror seeping out of my pores as I stood there thinking, if this goes badly, is my career over? What's going to happen? And I still remember she said to me, Mr. Tiedt, there are some things in this document I imagine your client might prefer not to have ventilated in open court. Oh, yes, Your Honour. Bang, finished, dismissed. And I was like, wow, that's all right.
Well done.
I think I can do this. This is great. And that was, what are we now, 16 years ago. And I can still remember where I was sitting. I can see Her Honour sitting up on the bench. It's burned in there until the day I die, I'm sure.
Well, I can't refer to the judge that I appeared in front of on the first occasion because they still sit on the bench. But I 100% remember it was a drug possession matter, and I was terrified. I mispronounced. I called it, I think, Seth instead of meth. It was just terrifying, and it was so scary. But at the end, I walked out, and much like, I guess, skydiving or something feels, you get the shakes, but you think, wow, this is pretty crazy. And then the client, we got him a great outcome, hugged me, and I just thought, I want to do this. I like clients that have a face.
That's good, man. Fantastic.
Let's go back in time. What would you say to yourself or anyone who's watching who wants to be a criminal defense lawyer someday, if knowing what you know about the path now?
I think something I still say to young criminal lawyers these days is, you know that feeling you've got right now where you feel like there's so much to learn and how could anybody possibly learn this, and you're overawed by the responsibility and you're overawed by, how am I going to make this work? Yeah, that feeling doesn't go away. No. That's a feeling I have every single day when I read something new, because the law is constantly changing. Clients bring new and exciting and challenging problems to you every single day of the week. Anyone who says to you, yeah, I've got this down pat. It's just a constant, almost trying to keep your head above water as the water constantly moves around you. You just have to every single day get up, work hard, do the best you can, and try to do the best possible job you can for your clients to look after them and represent them as best you can.
Well, 100%, and that's why we call it practice. You're in practice. It's not you're.
I'm definitely still practicing.
Yeah, exactly right. You practice every day because that's what it is. It's never perfection. It's always kind of all over the shop, and it's all sort of the challenges. And one of the real things about a courtroom, and I say this to all my clients, is this is battlefield medicine. We have a plan. Of course we have a plan. But when we arrive, the plan is going to explode.
Sure.
We might be allocated to a judge that perhaps is very unsympathetic to people like you. We might, for example, have a witness turn up that we didn't expect. The prosecutor might throw something. You might get good luck as well. You might show up and, hey, the witness didn't turn up. And so it's like jazz. And I think that what it's given me, at least in my personal life, is a very good ability to get pretty good at improvising.
Sure.
And dealing with the uncertain. Have you found that as well?
Yes. Court never goes the way you think it will. Stuff comes up. As you say, people don't turn up, or they turn up and say something entirely different, and you've just got to kind of pause and go, okay, and just bat on. So, and that, I think it's a skill that takes a long time to learn. The confidence and the ability to just go, okay, this is not what's going to happen, but we're just going to kind of roll with it. And that's a hard-won skill. I think it's something I try to apply. I have to apply every single day in the job.
Absolutely, and it's the ability to like water off a duck's back. I mean, people think that maybe we're ascetic or we're kind of monastic and we can kind of rise above it. I tell you, when I get an unfair outcome, or what I perceive to be an unfair outcome, because I'm often wrong. You can't be objective. You can't be objective.
Jahan, how dare you?
I know. Can you believe that someone would disagree with me?
I know, right?
But I do. You still do take it personally. What I have found, though, is the time between this is bullshit and unfair to this is life happens is getting shorter and shorter.
Sure. I mean, the other thing is I often say to people that I go to court and I work myself to the bone for that client, and I'll do everything I can within the boundaries of the law and the ethics. I will do everything I can to help the client, and I will do everything I can to get the outcome the client's after. One of the hardest parts of the job is when the result is a bad result, and whether that means your client gets a conviction or has a consequence that means they lose their job or even goes to jail. Of course, you take it seriously, and of course, you don't kind of are flippant about what's gone on, but you have to back up the day after and do it again.
Yeah.
So whilst I care enormously about the quality of my work, and I do everything within, as I say, the boundaries of law and ethics to help those clients, I can't take it personally in the sense that I have to come back tomorrow and do it again, and the day after and do it again. And if you live and die personally, and if you do take those things to heart in the way you might other circumstances, you just can't function as a lawyer. You can't back up day after day if you go home in tears every day. And that's not to say lawyers can't or shouldn't feel emotions. It is to say you have to have a thick skin to be able to deal with this really difficult circumstance and this really awful scenario, whatever it might be. Do what you need to do the best you can for your client, and win, lose, or draw, come back tomorrow and do it again.
Yeah. And it's that gift of perspective, isn't it? You know, when I recall this anecdote I often share, that many years ago I was visiting a client at MRRC, which is a prison here in Australia.
And not a nice one.
No, not nice whatsoever. And for some reason I was having a bad day. There was no valid reason for it.
Moustache wasn't curling, or who could tell?
No. It would have been a horrific day if the moustache wasn't curling, right? Like, one has to keep these things in perspective.
That's a sick day if I've ever heard one.
It's disgraceful.
Yeah.
But I recall that I basically went and I think I had a coffee and it was made wrong or it was bad. And I was just like, this is so unfair. I have the worst life ever. As I drove to remand to visit someone who's in custody for an offense that he says didn't happen and has spent months there. And it was, as I walked through the gates, I remember thinking to myself, you have your priorities all wrong. You need perspective. And now, whenever the small stuff comes up, all it takes is to draw upon the well of clients, some of which have, as I'm sure you've represented, people who've done nothing wrong but have fallen foul of the system and have gotten their arms caught in the machinery of state. And when that happens, it's scary.
Yeah.
And I mean, has it gotten? I feel it's gotten much harder to be a criminal defense lawyer over the last few years. I think the laws really have changed in substantial ways, including the 89A. Adverse inference that can be drawn against people. I think that generally speaking, there's a perception now that lawyers tend to be sneaky, sharp, or dodgy. And I find police are charging more than they used to charge. At least I think they are. What are your thoughts on that?
Look, it's gotten harder in some ways. I mean, in a sense, it's gotten harder for the clients more so than for me. My job is to help them. It's getting harder in the sense that often there are more obstacles in our way to doing what we're trying to do. But that's how it goes. I just go to work each day and try to do what I can to help my clients out. And if there's some new challenge, then there's a new challenge, and I'll be annoyed about it and whinge about it online and get going again. But I mean, there's a lot of ways in which the job is easier now on a practical level. I mean, when I first started practice, we were just introducing Blackberries. We didn't have, hotspotting on our laptops or being able to work on the go in the way we do now. So I'm grateful for lots of technological advancements, but the law is seldom moving in a way that helps out criminal defendants, and that's terrible, and it shouldn't be that way. But I mean, my job is what it is. I take the law as I find it and the facts as I find it, and just go do what I can within the bounds of what I can do.
You're a better man than me. I gripe about these things constantly.
I wouldn't want to. Okay, sure.
I gripe about these things. Like, for example, one of the things that I gripe about, and and I know it can work because it has worked, and it worked in Melbourne, is it was very common during COVID that if you had a first mention before the court, you could send an email. Now, the reason they took it away is because there was a small subset of lawyers who really abused it and took it to a ridiculous extent, which punished all of us who did the right thing. The technology is there. The system is there. The fact that we can't use it is upsetting.
Well, I'll tell you, my huge gripe is paper.
Yeah.
So I run what I call a paper light office. Paper free is a fantasy for lawyers. But I print only for court. So we have some great document management software. I receive paper sometimes, I scan it, I file the paper and never touch it again. And I run everything off a laptop and various online storage facilities that we have. And in that way, I don't print out things for reading. I read everything on my iPad and my laptop, and I work from that system. But when you go to court and you want to tender a document, or you want to show a document to a witness, or you want to have written submissions, they need to be in paper. So because the courts are still run on paper, because you can't just email your exhibits to the judge's associate, because we don't have the facilities to use the technology in the way that we could, we have this printer that's the hardest working kid in showbiz and just prints out reams and reams of stuff. I often say to people that for a jury trial, I will take a literal suitcase of paper to court, maybe 10, 12 lever arch folders stuffed with paper, and I will use 100 sheets out of that suitcase. I just don't know which 100 before. So the printer will print these vast reams. I will drag it to court. I'll pick a few pages out as we go along. Then I'll drag the suitcase back and I'll shred the lot. And it's just such a waste.
It is.
But the problem is, to change that, you need $1 million, $2 million, $3 million of investment now. That will save the lawyers of Sydney and therefore the clients of Sydney $3, $4, $5, $6 million every year. But you have to find people in government willing to invest that money. Another good example was AVL visits to jails.
Yes.
So the bad old days, you would drive out to the jail, you'd go through the scanners, you'd sign in, you'd go through 16 different doors and speak to all these different officers and need to get you to here. And after an hour and a half of stuffing around, you'd finally sit in person with your client and talk to them for an hour, then back out, drive. It was a whole afternoon for an hour with the client. And then when COVID happened, they wanted to stop lawyers coming into the jails for very good and valid reasons. So the government spent some money and they equipped the jails with a whole bunch of AVL suites where the clients could be dialed into by appointment. And suddenly they realized, hey, this is easier for us. We just take the punter, we put him or her in a room, they AVL to the lawyer, they have a chat, and we're done. This is much better. But it needed, I don't know how much money it was, but $5-10 million invested now to get it done. And now the government must save that much every single year. Absolutely. Through the officers that don't need to strip search the accused and and scan everyone through. And it's made the system better for everyone. But you need that investment now. And getting money out of government can be blood out of a stone sometimes. So I drag paper to court until someone wants to implement an IT system so I can just upload it and email it and across and on a screen and whatever else. But that's the big gripe I have about the way the system operates.
No, I think that's a completely valid.
Well, sorry, one of the big gripes. No, there's a couple.
Look, there's heaps. But I mean, the reality of the situation is, even the people who are lucky enough to engage us, that means they have the wherewithal, or they've got the privilege to understand how the legal system works, know that it's serious, find a lawyer who could speak their language, help them, guide them, do all those bits and pieces. And I think that it's really concerning that there isn't an understanding of this. I'm perpetually, I go to court, and sometimes there'll be people there who don't speak English and have no idea what's going on, and they're facing enormous consequences, and they don't know about things like legal aid, the Judy scheme, all of these things. I always try my best to go up to them and say, hey, can I help you and guide you? Because I feel like that's part of our obligation. But it has the power that courts have is unique. The Constitution imbues them with a lot of stuff, but two really powerful things. One is that they can levy fines. The other is that they can imprison people. That's the only branch of government that can do that. And for people that don't understand that, they go there, they think maybe they're going to the RMS. They just don't understand the severity. How do we increase legal education to make sure that people get it?
Well, I mean, this kind of thing's a start.
Yes.
Anything we can do to talk to the community is helpful. You and I both do a lot on LinkedIn to try to push the word out there. Now, that's mostly to a professional class because that's who's on LinkedIn. But there's an enormous amount we can do to speak to people in the community, whether it's one-on-one or through any other sort of platform, to try to help them understand, at least on some level, what courts are about and how they work. Courts are a mystery. I mean, people think they can go to court and just self-represent, and they can, and it isn't always a disaster, but it often is. And that's not because non-lawyers aren't intelligent, but it's because you can't just rock up and do a good job as a non-lawyer any more than I could rock up and operate on someone and pretend I'm a surgeon. It's not as simple as slicing and dicing. It is a difficult, complicated, convoluted process that you need to engage in. And it is almost impossible to self-represent well. There are exceptions, of course, but it does take a very long time and a lot of training and experience and education to understand how courts work and be able to present a case well. And that's not good. It would be, I mean, there's a utopian idea where the courts should be easy enough that anyone could represent themselves, but that's not the world we have today. It is difficult to do. And whilst we can't fix that problem ourselves, we can help people to understand what their rights and obligations are and help them to better understand their place in the community. And of course, provide referrals to appropriate places and people and lawyers who can help them when those times come.
No, I think you've nailed it. It's I always say this is not legal advice, but this is how the system works. And for 1 in 100 people, self-representing is probably the way to go. They don't have they don't have the resources to go private. They are they fall into the justice gap, which we all know about. Justice
getting
gap,
big every day.
Absolutely, the justice gap is the gap between people who can sort of make their lives spin their lives around, but make sufficient money they don't qualify for free legal services. And it's horrible because for a lot of people who are living hand to mouth, which is a lot of people right now in this cost of living crisis, there's this huge gap. And
I'm sorry, but the thing is, lawyers are expensive, and that's true. But
we're worth it.
There's also an extraordinary amount of work required to properly present a case for someone, and it'd be great if it could be more efficient, and there are ways it can be more efficient. But at the end of the day, if you want to balance justice with expediency, there is a middle ground, and you don't want to give up justice to make it more expedient. So a simple example, imagine a jury trial where someone says, I got beaten up. We could just hand up the statements and have a judge read the witness statements and make a decision. That would be expedient. That'd be cheap and easy. I don't think it'd be just.
No.
But on the other hand, when someone has to go through, say, a jury trial, a 1-week jury trial, that's an enormous expenditure that's required. So there's always an important question about the balance, but how we do it better. Is more efficiency here helpful, or is more justice here helpful? And I don't subscribe to the idea that who cares about expediency, justice over everything. There is a point where you need to say, well, no, we actually do need to get to the result here. But I think it's important to recognize the tension between doing it quickly and efficiently and doing it justly. And usually you can't have necessarily both. You can just try to find the best balance you can between those two competing desires.
Yeah, look, it's a jurisprudential question as old as time, right? And I mean, there are other systems in the world, like the civil law system, which follow a lot more of, hey, if A, then B, and you can kind of follow a flowchart to sort of know what the situation is. Here in Australia, in a common law adversarial system, you're right. There are safeguards. Some of those safeguards are, we have a right to challenge evidence. We're allowed to cross-examine. We're allowed to have voir dire on typical points of law and seeing whether or not something is or isn't admissible. These are important things. And I think that there will always be this tension. I guess the difficulty is often that people think it's simpler than it is. They literally think we 100%. Just wander in there like Harvey Specter and we just say, Your Honor, da-da-da-da-da, and then it's over. It's not. It's super duper complicated. I was recently representing a very very intelligent surgeon, someone who's got credentials that far outshine my own. And we get into court, we go through the motions, we get an acquittal. We walk out. They look at me and go, "What just happened?" Now, this is a smart person. This is a person who's very educated, but they couldn't follow along the back and forth and because court has its own language. It has its own rules. It has its own both explicit and implicit sort of rituals. And so for many people, they go, "Well, why are lawyers so expensive?" It's because we can navigate those things with you and for you. I wish I could charge less and get you the right outcome, but attention, what wins cases? Time and money. What buys time? Money. These are the two things that are always the case. And so experience has a value.
Yeah, I mean, people will say, I might go to court and do a plea of guilty for a comparatively simple thing, a drink drive or a drug possession, and it only takes 5 minutes to do the plea. But what you don't necessarily realize is the hours of preparation that went into those 5 minutes, and then the 15 years of experience that you've got under your belt, so you can do it as quickly as needed. I mean, the old cliche is, yeah, it took me 5 minutes, but it took me 15 years to get good enough for it to take 5 minutes.
Yeah.
And that's sort of the balance that needs to be struck somewhere between there is a lot of work that needs to be done and years and years of experience that need to be obtained to be able to, and not to mention the training and education, to be able to get that job done. So when it takes 5 minutes, it isn't taking 5 minutes. It's taking 15 years.
And that's one of the things I always tell younger lawyers. They go, "Wow, you can do this in 5-10 minutes." I go, "Yeah." And most of the time it'll go swimmingly because I know what I'm doing. But every 5, something will come up.
Yeah.
Something will come up that, oh, wow, this 5-minute thing is going to take me 3 days. Yeah. And getting to the bottom of those answers, random things. I was in a hearing recently where essentially one of the things was whether or not we could rely on CCTV footage taken in the home. And the legislation says, effectively, you can if you're the owner or occupier, but only the video, not the audio. And I'm having this debate in real time with a magistrate who's telling me, I interpret it like this. And I'm saying, well, I actually think we have to interpret it like that. The ability to have that discussion is predicated upon you knowing everything else in the case so well that when this hydra appears, you can slice its head and sort of move forward. Do you find yourself in those sort of push and pull situations that happen?
I've never seen the law turn into a hydra, but that's, I mean, the hard thing is that law is subjective. It isn't a science. You don't add
art, not a science.
You don't add 2, multiply by 3, carry the 1, divide by 7, and there's your answer. Almost everything about the law is subjective. The criminal law is as specific and as detailed and as clear as humans can make it sometimes. But even when the law is clear and even when the facts are clear, sometimes the application can be incredibly difficult. But the facts are never clear because person A says this, person B says this, person C says this, person D says this. They're all different. Very possibly no one's lying. Everyone's just kind of giving their perspective of what happened and their perception, their memory of what happened. And then some poor magistrate or judge or jury has to sit there and try to make head or tail of it. Because unless it's on video, it's hard to know what happened. Even when it's on video, often there's still so many shades of lack of clarity or subjectivity that it can be very difficult to work out what actually happened. We don't live in a world where everything that happens is perfectly and indelibly recorded for posterity. We have snippets, bits of information. I mean, I watched a video that another lawyer asking for advice showed me early this week, and it was a video of a fight in a jail. And the jail CCTV is pretty good most of the time, so there was good high quality, good frame rate video. But I watched it and my comment was, well, I need the sound. And there's no sound in CCTV, but my opinion was when I looked at that, depending what was being said, completely changes the perspective of what you're seeing. And so even in that case, even though we have, frankly, tip-top CCTV of what occurred, depending on what was said between the two people involved, it could absolutely go either way because it is subjective. We don't have this, as I say, indelible record of what occurred. We just have pieces of information, sometimes more, sometimes less, but there's still a very subjective decision that needs to be made. And that's really why, I mean, AI is such a hot topic and legal tech and all that kind of thing. Robots aren't replacing humans anytime soon because there's a subjectivity and a humanity about the law that is completely different to any sort of AI or machine-based process. No machine can effectively, or as well as a human, judge whether a version is credible or reliable or plausible. There's a very, very human side to what we do. And really, my view at least, is when we do our best work is when we're able to connect with the human that we're talking to, whether it's a magistrate or a judge or a jury of 12, is being able to take this information and present it in a way that makes your version that you're trying to push forward persuasive.
Yep. Doesn't
always work, of course, but that's really where the rubber hits the road for my work, at least.
I agree. And, whenever I conference a new client, I always say, there is never a client I've had that doesn't have at least one secret that didn't break my heart.
Sure.
And hasn't done one thing that I go, that's pretty cool.
Yeah.
People are very complicated. People are very gray. People are all over the shop. They've got, perspectives and shifts and whatnot. And it can be very challenging because there's a real difficulty and a sense of uncertainty with the human experience.
So the expression I've often heard judges in particular say is that we're all better than the worst thing we've done.
I like that.
Which I think is really fantastic, because especially from where we're sitting, a client comes to us and they either have done something or they're accused of doing something, and you do tend to subconsciously, unintentionally, almost pigeonhole the client into, well, they're a client of category X. And even if they have done the thing they're accused of, they are better than that. That doesn't define them as a human. Humans are such a cliche, but we're complex things, aren't we?
Of course we are.
We aren't just this single thing, the single fact sheet that says this thing that we're done. Everything happens for complex reasons. Everything happens or nothing happens in a vacuum, I should say. So I don't remember who I first heard it from, but I've heard it a few times since, and we're all better than the worst thing we've done is something I try to remember.
Yeah, mine is, not everyone's good, not everyone's bad. People are the average Tuesday. On an average Tuesday, if you're going out there and stabbing people in the head, you're probably a bad guy. But on an average Tuesday, if you're, a decent enough person and we are better than the worst thing we've done.
100%.
What do you think about people who want to start the criminal law now? Would you encourage it as a viable career path for a young lawyer?
I think it's a great career path if you're built for it.
Yes.
It absolutely is not for everyone. And I think that's a really important thing to note. Law, in the first place, isn't for everyone. But criminal law, maybe especially, isn't something everyone is suited to. And that's not a superiority that I'm trying to put out. It's not not everyone can be as good as Jahan, whatever. It's one of those things where...
Mustache-wise.
Exactly. I could say no one's as good as you mustache-wise.
Thank you.
I'll acknowledge that. It does take a certain personality type to do criminal law well, and it takes a real resilience. And that's not something everyone has. Now, in fairness, there are areas of law I'd be terrible at. Please don't ask me to draft your terms and conditions for your company. Please don't send me your... don't ask me to sell your house. Property law and conveyancing, and they can keep it. I'm so pleased that there are lawyers out there who are good at that work, because from time to time I need those lawyers, and that's fantastic. They can keep it.
Yes.
That is not for me. So I'm not saying criminal lawyers are better by any means. I am saying it takes a very particular kind of person to do it well, and to survive. The tough parts of criminal law are super tough. And it is an area of law that will break a lot of people because they don't have that kind of resilience. You need to be able to run a jury trial, lose that jury trial, because no one wins every trial.
Not at all.
Anyone who says they have is lying. Lose that jury trial, have that client go into custody, mop them up, mop the family up, go home, come back the next day and do it again. And the knowledge that the same thing might happen on that day. And that resilience is hard won. No one learns that straight away. But some people never or can't build that resilience. There's stuff you have to... the vicarious trauma in criminal law is significant.
Yeah.
There are a lot of people who it just breaks them when they're dealing with the kind of awful stuff that we need to deal with. It does wear you down, and not everyone has the ability to absorb, deflect, and get on with their day. As I said, that's not to any means to say that criminal lawyers are better. It's to say that resilience is something not everyone has. And if that's not you, that's not something to be ashamed about or worried about at all. There are many, many areas of law that have parts that would make me crazy, and I wouldn't do for love nor money. And that's just that's the world we live in today. So I guess my comment, and I've made this comment to criminal lawyers, to people who want to be criminal lawyers, is if you can cope with those things, if you feel that you are equipped with the resilience and the strong mental health, which makes a huge difference, if you feel that you'll be able to deal with that, the rewards of criminal law are fantastic. It is a always challenging, always interesting, fascinating area of law, and there is nothing else I'd rather do. But it is very not for everyone.
I agree.
But I wouldn't do anything else. I absolutely love being a criminal lawyer, and whilst I don't pretend every day is a good day, and I don't pretend that resilience is always easy, for me that's a shell I built up and an ability I built up to be able to absorb, deflect, move on. And for me, it's great. But certainly you need to, if you want to get into criminal law, you need to have a look at yourself and see whether you think you can cope with that, because not everyone can. And if not, you're best off setting your sights on something that will challenge you in different ways.
Look, the law's a wide church. There is so many different areas, and exactly, you know, if somebody asked me to draft a trust indenture, I would be not happy, and I would refuse that work. Yeah. But I think that for many people, there is an inherent sexiness and glamour to criminal law. I feel like when I go to a cocktail party
on TV, there is.
Well, yeah, but that's exactly right. TV has done a great job of creating this. You know, when you go to a cocktail party and you say, "I'm a criminal defense lawyer," people lean in. Most of the time, you say you're a lawyer, they lean
great
back.
Stories. Yeah,
you know, there's great stories. There's a lot of thing there, but it's not like TV.
No.
And like if you think that it's this glamorous, you show up, and it's not. You go to poorly serviced government amenities where you're dealing with people on the worst day of their life, and you're dealing with an overwhelmed and overstretched system. Financially, it's nowhere near as well paying as our cohort. You know, if money's your thing, go elsewhere.
Yeah, for
sure. There's no question that this is one of the. I think that you and I probably have really top tier practices, and I would say that compared to our family or tax colleagues, we make a 10th. Like it's.
I often say to people, criminal law is the worst paying area of law. I firmly do believe that, and the reason why is, putting to one side people who work for government who earn regular government salaries and do very, very good work. I'm not criticizing them at all, but those in private practice, there's really two flavors of criminal defense lawyer. There's those doing legal aid work, which is these people are doing God's work. They're amazing lawyers working very hard, but they are getting government pay for the work they're doing, so it's not great. And those who are predominantly private practices, like you and I, our clients are all borrowing money, they're selling their car, they're remortgaging their house. They don't have expense accounts. They don't have huge accumulated sums of money to spend on lawyers. They are scrimping and pulling funds together to pay for the work that needs to be done. I'm not crying poor by any means, but you're quite right. Criminal law is not the area of law where you're going to make the most money. In fact, I think on average, criminal lawyers are probably paid the least of any.
I would accept that
area of law.
I would definitely say that. Even if you've got a successful practice, and that's fine. That's because the other side of it and the work that you do fills you with a sense of purpose. And I think that the sense of purpose for me is worth it much more than money.
Yeah, absolutely. Absolutely.
What is a memorable mistake that you have made in practice that you still kick yourself about to this day? Don't worry, I will share my own.
One in particular. I think I often say to people that every part of the criminal law is difficult, and everything is harder than it looks. Cross-examination looks really easy on TV, or in real life, even if it's done well. It looks effortless, and it looks like something you can just turn up and do. And if you want to be disabused of that notion, pop down to our local court any day you like and watch a self-represented person try to cross-examine. It is, without any doubt, in my view, the most deceptively difficult thing that we do. And when it's done well, it looks effortless and easy. It is never effortless and easy. Cross-examining is something that takes genuinely years and years and hours upon hours of practice to get even good at, let alone very good, let alone excellent. It's something that many lawyers with decades of experience still haven't mastered. Well, no one's mastered, even gotten good at, let alone getting close to mastering it. And every single cross-examination I've ever done, I will look back after and go, oh, that wasn't great. Or, geez, I wish I'd put it that way, or I wish I'd phrased it that way. Cross-examination, to be clear, is when a lawyer is asking a witness questions and they're an unfavorable witness. They're witness the other side is called against your case. And you're doing one of two things generally. One, trying to get useful information from them, or two, trying to, by the questions you ask, demonstrate that the evidence they gave shouldn't be accepted. Now, cross-examination is a very, very deceptively technical task. It's something that's bound by incredibly strictly applied rules of evidence, but you need to do it almost entirely off the cuff. There's no good cross-examination that's ever been done that was written out in advance. You might have lists and topics and issues to cover and notes, of course, but cross-examination is something done on the fly to a very technical standard based upon mountains and mountains of rules and practice and procedure. I say all that to preface by saying every cross-examination I've done, I've not done perfectly. Every single one I look back on and I wish I'd gone about it that way, or I hear the answer and go, oh, that was a dud question. But you've just got to kind of roll with it and get on with it and ask 10, 100, 1,000 questions, all of which have to be legal. Every single one of which has to comply with the rules of evidence and avoid annoying the jury or the judge or the magistrate. So I'm not sure I can pick one, but I can tell you now, if we sat down with the thousands of crosses I've done over the years, I will get a highlighter and highlight at least one, probably much more than one question where, geez, I wish I'd done that different.
I can tell you, because I've done a lot of cross, and I can tell you that I've never left and said, yeah, woo! The best I've done for me is, that went okay. If I can finish a cross-examination, go, that went okay, cool. And I've got 1 point out of it, I'll be happy.
Can I tell you something I often think about? One of the TV has ruined people a lot, and TV has completely misled people about what courts are really like in 101 different ways. But the biggest way in which it has misled people is about confessions on the stand. I can tell you right now, in all my years, I have never seen it happen. I have never heard of it happening. No defendant has ever, after an hour of rigorous cross, gone, oh, I admit it, I did it, I shot him, I confess. It never happens. No police officer has ever admitted, oh yeah, I planted the evidence. Whoops. That is a myth that TV has bred, where the ultimate goal for cross-examination is to get them to confess. And it just doesn't happen. Defendants, police officers, witnesses, people just don't do that. What you can do, and then that's something I say to clients, because they often think, well, that's what you're going to do, isn't it? You're going to get them to confess they're lying. I'm not.
I'm not a wizard. This isn't Hogwarts.
Exactly. What you can do, I mean, you can leave. You can cross-examine in a way where, when you eventually suggest you've made it all up, haven't you? Of course they're going to say no. You know they're going to say no. But if the last half hour has gone well, that answer is ridiculous, and you can get to the point where, when you kind of reach the not the punchline, but the apex of what you're trying to do, when they eventually don't say what you'd ideally love them to say, you'll have it at a point where their answer just seems like a ridiculous answer. And that's the best you can hope for. It's never as exciting. It's never as dramatic. It's never as entertaining as on TV. One of my all-time favorite movies is A Few Good Men.
Oh, of course. I thought you'd go there.
No, I want to, because Jack Nicholson is one of the greatest actors of our generation. I can see the microphone's bowing at the mention of Jack's name.
He's got that star power.
And it's a brilliant, brilliant, brilliant movie. And I love it. And I must have seen it a dozen times. And incredible as the final scene is, no spoilers, it's just never going to happen. No one's ever lost their temper that way in court near me. People have gotten pretty annoyed, I can tell you that. Being cross-examined is an uncomfortable experience, I can only assume. But people never, ever confess on the witness stand. All you can do is in a far less dramatic, far less exciting way than on TV, is make the answers that you believe to be untruthful seem ridiculous. And if you can get that far, you're probably a very long way towards winning the case for your client.
Yeah, it's true. And sometimes I used to think that a good cross-examination was exactly what you'd see on TV. The person breaking down, Sometimes it's getting them into a place where it's exactly what you've said. Their answers are so incongruous with the evidence that's otherwise there that you can't accept what they're saying. Exactly. Whether it's because of dishonesty, whether it's because of a forgotten memory, it's hard. And it's very uncomfortable for people that you're basically calling them a liar, and not only a liar willing to get on the stand, perjure themselves, and cause these issues. What do you see the future of the law as being? Do you think that the criminal law will change in any meaningful way? Do you think it will continue to get harder for defense? What do you see?
I mean, the hardest part of my job is that criminal law changes every 10 seconds.
Yep.
There's new laws, there's new regulations, there's new procedures. Hopefully you hear about them before you experience them. But the law
Not
is...
always.
No, exactly. The law is a constantly moving feast. So that's always challenging and difficult. And there's new crimes being invented and new laws, in terms of there's new criminal laws being invented, I should say. And there's constantly new processes that we need to try to stay on top of so we can serve our clients well. So that change is never going to change. Lawyers as a class are phenomenally technophobic. And of course, our courts are run by lawyers who become judges and magistrates. So our courts are very technophobic. And it often amazes me and amazes my clients who aren't experienced by courts, where you walk into a courtroom and the magistrate comes in and he or she has 3 or 4 foot-high piles of paper that they work from for the day. And people look at that and go, is that really? Yes. They get the paper, they write down the answer, it goes up back, someone reads the chicken scratch, and they type it in the computer, and we go from there. And that is how courts work today, which to almost any other profession, from, whatever kind of profession you want to imagine, that's extraordinary. How can we be so technophobic? But that is the structure of the legal system. So to answer your question, we've had a few areas where the law has become more technologically savvy as a profession, and that's fantastic. AVL visitor jails being the best example. But there's a very, very long way to go. It's going to take enormous investment and determination to drag the law kicking and screaming into the 21st century, which will hopefully happen before the 22nd century comes along. But the biggest change is hopefully going to be the law becoming more technologically savvy and realizing that it's in everyone's interests if we can use technology in a way that better enables lawyers to serve their clients, better enables government lawyers to do their job and to serve their client, the people, and better enables the courts to dispense justice in a way that is fast, efficient, and just. It's not easy. It takes incredible determination and effort to get it done. But I am hopeful that over time, slowly, inexorably almost, we'll see the law getting better at using the technology that we have. And that can only improve things for the community, both in terms of cost for the courts, so the taxes that we pay for funding the courts, cost to litigants who will pay lawyers less, I hope, because there'll be more efficient ways of doing things, and the outcomes being better. It's a process, it's subjective, it's slow, it's tedious sometimes, but that's what I'm hoping we'll see more of.
I'm buoyed by your optimism. I hope that that's the case as well. For me, I look, I think that that's the only chance we have of. I see the delays getting longer and longer. I see people waiting extraordinary amounts of time for their day in court. I see a lot of sociological changes, people becoming skeptical of the legal system without any real basis, rise of things like sovereign citizens, which I think is fueled largely by cultural shifts and paradigms like being very, very exposed to social media bubbles that tell you what they think you want to hear, unscrupulous third-party operators. And I slowly and sincerely worry people will start to lose faith in what is the most beautiful system ever. And I hope we can do an about face, but I think technology is a key part of that, right? If we could make the system even 10% more efficient, you'd get through a lot more of these cases and you'd have people getting their day in court. Because at the end of the day, everyone deserves their day in court. That's the purpose of it. You have a right to fight your case as you see fit. You have a right to be heard. And I think that the coalface of the law is the one taking the most brunt of that.
I think that's right. Absolutely.
Where can people find out more about you?
Our website for the firm I run is www.jsuttonassociates.com.au. So that's where I do my my business side of my practice. I'm busy on LinkedIn, writing about the law, chatting about the law, meeting people, networking, trying to help anyone who wants to listen understand the law better. And I have a website I'm very proud of called trialdirections.com.au. That's a website really geared towards criminal lawyers. So it might be fairly incomprehensible to most non-lawyers, but it's aimed at those criminal lawyers to help them be better at what they do.
Can I tell you, on Monday I used it to come up.
Good.
Yeah, I used it specifically for my Liberato direction.
Outstanding.
It was I still lost, but that's not a criticism of your
on
site.
you, wasn't it?
That's really much more about the advocate who misused the information. But
it was there.
It was there. It was there, as was all the relevant cases. It's a fantastic. When I was growing up, there was a criminal law survival kit.
I remember that.
Yeah, it was a fantastic resource. It was phenomenal. I think it was by a public defender.
John Stratton.
John
Senior
Stratton.
counsel.
He's fantastic. He's a good man. Can I just say thank you so much for coming on the podcast, talking with me today, sharing your anecdotes, sharing your stories, and the passion. It's a privilege to work with you. And tune in next week for another episode of Cross-Examination with Jahan Kalantar. You did very well under cross. There was no jailbed confession, but it was a pleasure to speak to Andrew. Bye, guys.
Cheers.